a distribution business with a national footprint, many hundreds of employees, going concern business. The private credit providers supported a non-bankruptcy process. Like you say, not public, right? So there was an investment banker running the process of finding interested bidders, selected a winning bidder, implemented the deal through an Article 9, essentially foreclosing and selling the business as a going concern, followed by an assignment for the benefit of creditors, which put into place a procedure to address claims and liabilities that the buyer did not want to take. And on top of that, the ABC assignee performed transition services. For a large distribution business, it took time. It would take time to move that business from a seller's platform onto the buyer's platform. So it's all the sorts of things that you often would see done through a Section 363 sale and follow-on Chapter 11 plan, but done much more quickly and in a manner that is much less costly. So I think it's a fascinating thing that, at least from my takeaway, was I better start brushing off on some Article 9 non-bankruptcy strategies, which I just historically haven't really had opportunities to use. But I do see kind of opportunities there in the private credit space.
We're talking about innovation. There's so much private credit now, and that actually, before I went on the bench, I represented a lot of the earlier distress funds. Oaktree was a big client. I heard a woman from Oaktree recently saying they're actually expecting a lot of those private credit loans to default because they're not very sophisticated folks, particularly not sophisticated with default. And so they're dusting off their playbook from the early 90s to buy up that debt a year or so from now. So some things don't really innovate, they just circle around again.
Hello there, M&A Advisor community. This is Roger Aguinaldo, and welcome back to the M&A Advisor podcast. Since 1998, the M&A Advisor's mission is to recognize achievements, provide thought leadership, and connect professionals in mergers and acquisitions for the purpose of improving your deal-making craft and accelerating your deal flow. We are so glad you're joining us for this insightful and inspiring podcast conversation curated for mergers and acquisitions professionals. Whether you're an aspiring deal maker, a seasoned professional, or just curious about the world of mergers and acquisitions, you'll find something valuable and relevant in our podcast. Our goal is to bring you the best insights, stories, and tips from the experts who've been there and done that, so you can learn from their successes and mistakes and take your deal-making skills to the next level. But before we dive into today's episode, we have a small favor to ask you. If you enjoy listening to our podcast and find it useful, please consider following us on Spotify, Apple Podcasts, and YouTube, and subscribing to our M&A Alerts newsletter. You can find the links in the description below. This will help us reach more people like you and grow our community of M&A professionals. It will also let us know that you appreciate our work and want us to keep producing more quality content for you. Plus, you'll never miss an episode, and you'll always be in the loop with the latest trends in the M&A world to improve and accelerate your deal making. So please follow us. You are the reason we do what we do, and we couldn't do it without you. And now for today's podcast.
It is my great honor to introduce our next panelist, Judge Robert Drain, retired from the Southern District of New York, was one of the most respected bankruptcy judges in the country, presiding over numerous cases of significance over his tenure. I was born and brought up in White Plains, New York, and it became a bankruptcy hotspot only when Judge Drain was assigned to man the Southern District of New York courthouse in White Plains. He never, in my view, made a wrong decision except once, and I don't hold it against him. But he is probably best known, well, I should leave that to him, for the Pharma cases, the Purdue case, which was miraculously solved at the bankruptcy court level, then went up and down through various levels, and finally concluded at the Supreme Court of the United States. discussing and interviewing is Evan Hill, who is a partner at Skadden Arps. I regret I was retired out of Skadden Arps before I had the pleasure of being his partner. But as Goffman and I were talking about earlier, we knew for sure he was going to become a partner. And so with that brief introduction, I turn it over to you guys.
Thanks, Greg. I got to say, Evan was one of those 40 under 40s when he was 20.
That's very kind. So Judge Drain, it's wonderful to be here with you, friend and colleague. And we had a lot of trouble landing on one topic to cover. So we're going to try to cover as much as we can, sort of in a lightning round approach, but with a common theme of innovation and creativity that we're seeing in the restructuring and distressed marketplace. I think it's what's so just great about this industry and this line of work is that practitioners and principals are just constantly having to be creative and find solutions to intractable problems. So with that, let's jump right in. We're going to try to cover our third-party releases, liability management exercises, equity-linked dips, cross-border restructurings, and private credit restructurings. Now that's a big agenda for 20 minutes. We'll see what we can do. But first topic, a perfect one for Judge Drain, Purdue, as Mr. Milmo alluded to in the introduction, went up to the Supreme Court. So I want to ask you what you think about the Supreme Court decision, but we'll focus more on what it meant and what it did, right? And just in a nutshell, it ruled that non-consensual third-party releases are unavailable under the Bankruptcy Code. But it didn't speak to what is consent. Consensual releases are alive and well and available. It also didn't speak to Chapter 15 cases. And if there's a non-consensual third-party release properly implemented through a non-U.S. process, can that come back to the U.S. and be recognized through Chapter 15? So with that backdrop, Judge Drain, could you speak to some of the creativity we're seeing in the market on this topic?
Sure. The story of the Bankruptcy Code is one of lawyers and investment bankers and turnaround people finding ways to do things that need to get done, even if they're blocked in other ways. And certainly the post-Purdue landscape reflects that. The process actually started even while Purdue was on appeal, but there are many ways to deal with the inability to force a release on with respect to third-party claims, which, by the way, was very rare and unusual to begin with, where it really counted. The first is a renewed emphasis on what are estate claims, or claims that the estate has standing to bring, which has highlighted a number of cases. For example, the Kitafenwal Forever Chemicals case depends a lot on that result. Secondly, as Evan said, Supreme Court said that you could still have consensual releases. There's an ongoing judicial debate at the bankruptcy court level so far. It actually predated Purdue also on what constitutes consent. Can you opt in only, or can you be forced to opt out and otherwise be deemed to consent? There are two excellent opinions out there right now that take different views of that issue. One by Judge Goldblatt in Delaware that basically says, unless you vote on the plan, you have to opt in. And one by Judge Lane in the Spirit Airlines case, which said opting out was fine. I was pleased that he cited one of my cases at the beginning of that opinion, which says that a bankruptcy plan is not a contract that everyone signs. It's only signed by the proponent of the plan. And so basic contractual principles don't really apply. You have to look at federal law to figure out how to answer that issue. But there'll be much more on that front going forward, including a focus on notice to third parties if you're giving an opt-out type of plan. The obvious solution in a lot of these cases is to hold money back from a settlement, particularly if you don't want to go through the appeal process, which the United States Trustee's Office is doing on every opt-out plan. So as seen again in the case law before the case, in the Endo case, where they didn't want to deal with a lot of appeals, as well as in the current Purdue plan. There's a significant reserve that's allocated to those who have third-party claims and will only be paid to them if a significant number of them opt in and is otherwise reserved for them. Lastly, there is a fair amount of thinking, at least, about using foreign cases where the law is much more receptive to third-party releases. In essence, the law in Canada right now is very much like what the Second Circuit law was before the Supreme Court case in Purdue, and recognizing a foreign case that has third-party claims released in it under Chapter 15, I think most people believe is a lot easier to do. The problem with that approach, though, is that outside of the U.S., there just isn't a mass tort body of law. And if you're trying to use a plan to deal with mass tort exposure, which is probably the quintessential case for a third-party release, the foreign courts are just going to scratch their head. In Holland, for example, which has a very innovative now reorganization law, it doesn't reorganize tort claims at all. So they're mystified by the idea of dealing with tort claims in a plan.
Mm-hmm. Great observations. Let's stick on the topic of cross-border restructurings for a moment. And what in my own mind, it's sort of a paradigm shift that we've been watching play out over the last couple of years. When you think about kind of historically, the U.S. system, Chapter 11, has really been viewed as the preeminent business and company-friendly restructuring regime for a lot of reasons. But number one is most glaringly, incumbent boards and management remain in place. They have the ability to exercise their business judgment to design and implement restructurings, as compared to how a lot of non-U.S. regimes historically worked, and many still do, that are very different. Incumbent boards and management are booted out. An insolvency practitioner, an accountant type, or financial advisor, but not an operator, is installed and normally would liquidate assets and distribute proceeds to creditors. But we're seeing a lot of jurisdictions really shift and implement regimes very similar to Chapter 11, and in some cases go even further in terms of providing flexibility to implement restructurings. So, Judge Drain, what are your thoughts in terms of that shift?
I think it's very significant. The older people in this room probably could count 4 or 5 major changes in our business since they started practice, like the move of the banks and the insurance companies out of the business and distressed buyers and then hedge funds coming in, and growing sophistication, both on the creditor side and acceptance of Chapter 11 as a tool. I think this is one of those shifts, particularly in Europe. You have insolvency regimes in place now, in part because of European law, that are on their face reorganization friendly, regimes that let you deal with one tranche of debt or 2 tranches of debt, regimes that let you do that in essence privately and yet ostensibly under the supervision of a court, so you don't have some of the publicity issues that you've heard about today. So at this point, and also regimes that are dealing well with corporate groups and are very flexible. So at this point, if you have a multinational business, you have a real menu to choose from, and that's very significant. At the same time, I think Asian restructuring has improved dramatically, particularly with the advent of the sophistication of the Singapore court. I was active in helping Singapore's International Arbitration Center to develop something that they just announced, which is a whole protocol for arbitration in insolvency matters or distressed matters, which I think particularly in Asia will be significant because it's private, so that companies and families that don't really want to air their laundry in a public case can deal with distressed situations. and it recognizes the ability to agree after the fact, not in the underlying debt agreements, but after the fact, to go to an arbitrator, who the Singapore SEAC Center is, organizing a panel of people like, Greg Bilmo to serve that role if he wants to. So very interesting developments worldwide.
Yeah. Now, and let's shift now towards a couple other topics relatedly kind of interesting and creative transaction structures. We'll pause on liability management exercises. Certainly a topic that's obviously gotten a lot of attention lately, tons of momentum behind. Sort of ran into a hiccup if you look at the Simmons decision, the Fifth Circuit, which ruled that in an up-tier style LME, the open market purchase provision, which was the provision used as an exception to the generally applicable sacred right that all lenders are treated ratably, that was not properly used in that case because the transaction wasn't actually performed on an open market. It was not on the secondary market for syndicated loans. It was more of a privately negotiated transaction with a majority group of lenders. So on the one hand, viewed as a hiccup because that's a popular structure to use for up tiers for LMEs. But obviously, even since then, I think the momentum's just continued to build, and we've seen a lot of creativity in terms of how market participants have responded. So, what are your thoughts? Is that actually a hiccup, or simply just a reason for additional creativity?
I jargon changes, but I don't really think of LME as a new development. It's just a restructuring. I think what changes is the aggressiveness of it, and I think CERTA does evidence, as do some other matters that are working their way through the courts, that pigs get fat and hogs get slaughtered, and I think the market will adjust, hopefully, because the consequence of unwinding one of these transactions is really kind of frightening for everybody, particularly those who put new money in on the assumption that the transaction was going to work. But I think until boards face liability for approving these types of transactions, they're going to happen because restructuring makes sense. Particularly, this is a change, I think, because bankruptcy cases, as an alternative, are so incredibly expensive these days. I know lawyers and investment bankers don't like to hear that, but if you're even a modestly sized mega company, and you're looking at $150 million of professional fees for a bankruptcy case, you're going to do whatever you can, and your creditors will too, to try to avoid that. So there's an incentive to do these types of transactions, but people just you can't just take the trading mantra that it's all going to work. And I think the better advised companies are recognizing that, including the creditors of those companies, and maybe not being entirely fair, but fair enough to avoid challenges.
An interesting comment that you made there in terms of boards potentially facing liability is your view that so-called creditor-on-creditor violence will continue absent that sort of an outcome. And are you viewing that as a real risk that boards should be focused on?
I'm surprised it hasn't been raised more often. The statute says hinder, delay, or defraud creditors. You're delaying someone by leaping someone else ahead of you. You go back to Dean versus Davis. I don't know. I mean, I think, again, creditors, as we heard in the last panel, are now organizing to try to avoid some of that violence, which is great. But it's always tempting, and the check really should come from the board and the debtor to police them. You don't have tons of leverage, but you have the law on your side. You just say, don't be so greedy, because we're all going to regret it.
Right. And, we're also seeing liability management exercise insurance policies starting to be available as well. I think there's a lot of angles of risk and mitigants that are coming to bear.
That's true, although, I'd rather pay a lawyer to tell me how to do it right than pay an insurance company to protect me if I do it wrong. But
exactly. you mentioned costs, and I want to speak a little bit about private credit, and kind of what we're starting to see in earnest involving private credit restructurings, which I find fascinating, right? I think we've all seen numbers in terms of the size of the private credit market, and the ranges are all over the place, but I think it's fairly established at this point that market is larger than each of the broadly syndicated loan market and the high yield bond market. So we're talking, $1.5 trillion of private credit instruments outstanding, and how that translates into restructuring. So what we're starting to see is, to the point of cost and to the reasons why one might file for a Chapter 11 and use the bankruptcy tools to restructure, is that with private credit, you don't have the issue of holdouts that you would have in a broadly held issuance. You don't have collective action problems. Who you need to deal with is right there at the table. It might just be one lender or a smaller club of private credit providers, highly sophisticated parties, that if you can reach a deal with, you can implement outside of a bankruptcy, but also through a process. So we've gotten more calls on Article 9 transactions, assignments for the benefit of creditors in the past few months than I've received in the past decade, involving private credit instruments and looking for fast, less costly methods to implement deals.
Less public.
Less public as well. Just anecdotally, we recently completed one for a distribution business with a national footprint, many hundreds of employees, going concern business. The private credit providers supported a non-bankruptcy process, like you say, not public, right? So there was a investment banker running the process of finding interested bidders, selected a winning bidder, implemented the deal through an Article 9, essentially foreclosing and selling the business as a going concern, followed by an assignment for the benefit of creditors, which put into place a procedure to address claims and liabilities that the buyer did not want to take. And on top of that, the ABC assignee performed transition services. For a large distribution business, it would take time to move that business from a seller's platform onto the buyer's platform. So it's all the sorts of things that you often would see done through a Section 363 sale and follow-on Chapter 11 plan, but done much more quickly and in a manner that is much less costly. So I think it's a fascinating thing that, at least for my takeaway was I better start brushing off on some Article 9 and non-bankruptcy strategies, which I just historically haven't really had opportunities to use. But I do see kind of opportunities there for in the private credit space.
Yeah, well, we're talking about innovation. There's so much private credit now, and that actually, before I went on the bench, I represented a lot of the earlier distress funds. Oaktree was a big client. I heard a woman from Oaktree recently saying they're actually expecting a lot of those private credit loans to default because they're not very sophisticated folks, and particularly not sophisticated with default. And so they're dusting off their playbook from the early 90s to buy up that debt a year or so from now. So some things don't really innovate. They just circle around again.
Right. All right. Last topic. Another innovative transaction structure, equity-linked DIPs. So DIP facilities that, rather than being repaid in cash, have either the option or a requirement that they're repaid in shares of the reorganized debtor. So creative kind of loan-to-own sort of a deal structure. There's obviously a temporal issue, right? That you have a DIP facility implemented at the beginning of a case that hardwires in how reorganized equity is going to be distributed. Now that's without a plan being prepared, let alone solicited, voted upon, and confirmed. And so there's criticism that that's not the right way to have reorganized equity hardwired into the case without going through those sort of protective processes.
Right.
But what do you think
Well,
in
again,
terms of...
it depends on the pricing, right? I mean, it's good to have a runway, particularly if it's the debtor's option. On the other hand, sometimes it's good for a debtor, but not necessarily good for the process to buy off people to get their votes. And at times, these types of dips or backstops are used for that. I look at this, again, beware of the jargon, think through the jargon. Is someone getting something that they don't deserve as part of these types of deals? Is it really fair? And the courts are just catching up to that inquiry. In the Tam case, Judge Garrity actually had a trial on the value of a loan like this and whether it was overly generous to the lenders. Once you get into that type of topic, it's very difficult because loans in bankruptcy cases are often sui generis, but it's the only way to look at it, which is a very simple way. Is someone getting an unfair advantage based on the valuation?
Well, miraculously, we made it through all of our topics in 20 minutes.
That was a lightning round.
Thank you. And if there's any topics that folks want to talk about afterwards with either of us, we'd be more than happy to. So thank you.
We hope you enjoyed this episode and learned something new from it. If you have any questions or comments for us or any of our guests, please feel free to leave them in the podcast platform of your choice or send us an email at editor@maadvisor.com. We would love to hear from you and get your feedback. And if you haven't done so already, please follow us on Spotify, Apple Podcasts, YouTube, and subscribe to our M&A Alerts newsletter at the links in the description or on our website at www.maadvisor.com. This will help you stay updated on the latest M&A interviews and trends and support our podcast to grow and reach more listeners like you. This is Roger Aguinaldo, the creator and founder of the M&A Advisor. Thank you for tuning in and being part of our M&A Advisor community. Until next time, stay safe and happy dealing.